Hi, Tony DeWitt here. I'm a Missouri appellate attorney, and I try to make sense of the law here on YouTube. So today we're going to talk about something that I get a lot of questions about, which is opening the door and what that means. I'll have more on that in just a moment. The way someone opens the door to evidence in a courtroom is fairly simple. They make an issue of something that they have previously tried to keep out. I'll give you an example from a real case, although I'm not going to name the parties. This was a motion in limine that was filed by the plaintiff in that case, and the plaintiff was suing for damages for an explosion. What is a motion in limine, you ask? Well, a motion in limine is simply a request by one side or the other to exclude certain evidence. For example, in this case, to exclude an OSHA report. But it can be any kind of evidence. It can be photographs, it can be video testimony, and as long as there is a valid evidentiary reason to exclude the evidence and the judge feels that the evidence should be properly excluded, the motion in limine will often be granted. Sometimes parties even agree that they will not introduce certain evidence, and that's what makes for a motion in limine. So here's what that motion in limine in that case said. I'm going to paraphrase a little bit. Prior to a voir dire examination of the jury panel, that's where people are seated in the jury box and start talking about some of the issues in the case without presenting any evidence, trying to find out if the jurors are going to be fair and impartial jurors in this case. Plaintiff asked the court to instruct defendant, defendant's counsel, defendant's representatives, and all witnesses who may testify to refrain from directly or indirectly mentioning, referring, or to in any way alluding by introducing evidence or otherwise, making any statement about or asking any questions about the Occupational Safety and Health Administration, OSHA's recommendations in this case. And then the reason for that, they said, was because it's not a safety standard. And that is the law. The OSHA's recommendations are just that. They are recommendations. They are not safety standards. So let's suppose that the plaintiff prevails on that motion. We have a motion in limine to keep out this particular evidence. And the motion in limine prevents any party from introducing any evidence of this nature. In other words, you can't get a motion in limine to act as both a sword and a shield to keep somebody else from introducing evidence, but allowing you to do the same. So let's suppose in this case, the plaintiff says during his direct examination, well, nobody ever criticized me for what I did that day, except OSHA did criticize him or his heirs or whomever that day. There is criticism in the report specifically of his actions. The plaintiff has now opened the door, and that report is going to come in. Again, this is in order to keep it from being used as both a sword and a shield. But here something interesting happens. Here the plaintiff will ask for a limiting instruction. In other words, they are going to ask that the court tell the jury can consider this for criticism of the plaintiff's behavior, but it cannot consider it a governmental standard. In other words, the judge might say, the jury is instructed that this evidence is being admitted for the sole purpose of showing that OSHA had some criticism of the gentleman's conduct. But the jury is instructed not to use it as a governmental safety standard. Now, the problem, obviously, with that kind of instruction is it's a little bit like telling the jury, I don't care what you do not go back in that jury room and think about dancing pink elephants in tutus, because I don't care what you do. Somebody telling you not to think about something makes you think about it. But the purpose of a limiting instruction is to limit what the jury can do with information. And usually jurors are pretty good about that. They're usually pretty good about following such instructions. So that is the story of how we open the door to evidence in a case. We open it by talking about that evidence that we have previously asked to keep excluded. If you do that, you open the door and the evidence is probably going to come in. So there you have it. If you have any questions, please leave them down below in the comments. And if you would, I'd appreciate it if you'd smash that like button for me. You know, smashing the like button, it makes you feel good all over, and it doesn't cost you a dime. And more importantly, it helps me produce additional content because it tells the people at YouTube that this content is valuable for other people. So I would really appreciate it if you would smash the like button for me. Also, if you haven't already, you can press the button over there to the right that says subscribe, and that icon will pop up 3 bells, and if you tap the top bell, boy, say that 3 times fast, tap the top bell, it will give you a notification every time we release a video on this channel. Thank you so much for watching, and have a terrific day.